Lawyers of Reddit, what's your best, most savage I rest my case moment? Story 1. I had this client Gene and I represented him in 3 child support matters. Yep, 3 different moms, 2 dependency matters, like child protective services, and at least 4 criminal matters. Gene didn't have any money, so when he got in trouble, he'd ask the judge to appoint me as his attorney. Gene was a combat vet who did 4 or 5 tours in the Middle East. He was completely broken by the experience, and the VA just screwed the guy over and over again. So one day I get a call from Gene. He's been arrested for domestic abuse. He's alleged to have thrown objects at his girlfriend, plates, a vase, beer bottles, etc. Gene has 3 prior assaults on his record, including 1 domestic, so instead of looking at probation and a week in jail, Gene's now looking at going upstate for 5 years. Gene tells me the story. He picked up Veronica at the bar a week before he was arrested. Veronica was married and lived in a house behind Gene, and for the week before he was arrested, Veronica was hopping the fence to run over to Gene's house. She'd get loaded and then hop the fence again before her husband came home. According to Gene, they'd made out and stuff, but they'd never slept together. In Iowa, the domestic element of a domestic abuse claim requires that the parties live together, have a child in common, were once married, or are currently having physical relations. So I got myself appointed to the case, and I moved to have the state pay for expenses related to deposing Veronica. I scheduled the deposition with the county attorney prosecutor. Veronica had been telling the county attorney that she and Gene were in a relationship. When I sit down to depose Veronica, I ask her 2 questions. Have you ever slept with my client? Do you have a toothbrush at my client's home? She answers no to both. I take a break and have a chat with the county attorney. She agrees to let Gene plead out to a disorderly, a $65 fine. That was the shortest deposition I've ever taken. Before we continue, do us a quick favor. Smash that like button and subscribe to support our channel. Story 1. I once witnessed a pretty wild case involving a disputed will. Basically, it was 2 sisters fighting over their late mother's house. Sister A had been living with their mom and was known for mooching off her. Sister B, on the other hand, lived farther away but seemed genuinely caring and involved in her mom's life. After their mother passed away, a will suddenly appeared, but only after Sister A and Sister B got into a heated argument about what to do with the house. Sister B wanted to sell it and split the money fairly. Sister A, of course, wanted to keep it all for herself, free and clear. Now, I might not remember every little detail perfectly, so I'll stick to the highlights. Sister B's lawyer, the defense, had gotten a hold of a bunch of angry voicemails Sister A had left on Sister B's phone. These hadn't been submitted during discovery, so Sister A's lawyer had no clue they existed. On the stand, Sister A claimed their mother was totally lucid and mentally sharp right up until her death. She insisted the will was written with a clear head just before she passed. The defense attorney made her repeat that under oath, then reminded her of the seriousness of lying while under oath. That's when the defense pulled out the voicemails and introduced them as evidence of perjury. Sister A's attorney objected, but the judge allowed them. Procedural rules made exceptions when it came to proving someone lied under oath. The voicemails? Brutal. Sister A was raging at Sister B, saying she'd never let her have the house, that their mother had completely lost it, was mentally gone, had dementia, couldn't function, on. And she flat out said she'd do anything to keep Sister B from getting a share. Sister A turned ghost white. Her lawyer literally face-palmed in court. You could feel the energy in the room shift. In the end, the judge ruled in favor of Sister B. The will was declared invalid. Sister A was ordered to vacate the house, and it was to be sold with the proceeds split between them. It was a brilliant move by the defense, completely changed the outcome. Even the judge looked impressed. Story 2. I have 2 that I like to share. The first involved a lawsuit against the owner of a Mexican restaurant for not paying his employees and keeping the waiters' tips. He was just a terrible all-around guy. He created these fake handwritten schedules and payroll records going back to years to try and prove that his employees didn't work but a few hours each week and were paid for what they did work. It was difficult to prove they were fakes, but we managed to trap him during his deposition. I had the guy walk through random parts of his work schedule to confirm their accuracy, picking a week here and there in February, March, April. Everything seemed routine. Then we got to May. I asked, So in early May, you had 2 servers every night, 1 hostess, 1 bartender, and 2 cooks. He confirmed. I pressed him further. No extra staff needed on weekends. Still no. Steady staffing, he said. No matter the day. So I picked a specific date. What about this Wednesday? Same as every other night, he replied confidently. And what date are we looking at? May 5th. I nodded. So just to be clear, it's your testimony under oath that your staffing needs on May 5th were the same as May 4th and May 6th. Yeah. At this point, the opposing counsel was already shaking his head. I leaned in. So you're comfortable telling the judge and jury, under oath, that your Mexican restaurant didn't need any extra help on May 5th, that the staffing records and payroll you've submitted are completely accurate for Cinco de Mayo. There was a pause, then a quiet, yeah. Oh no. The case was settled within a week. Case 2, state law enforcement was trying to prosecute a local cop for accessing name and address information for an individual in the state's criminal justice computer system to help a friend who was a process server. The state was prosecuting the cop for violating the Computer Crimes Act, which in part makes it illegal to share any information which the state has an intellectual property interest in. We show up for trial, having waived our right to a jury, and allow the head of the Attorney General's litigation department to make this wonderfully colorful speech about a police officer breaking the public trust and this other nonsense. For our opening statement, we move to dismiss the indictment on the grounds that the state's theory of the case is a legal impossibility. The state cannot have an ownership interest in someone's name or address. The judge was annoyed with our tactic and put the screws to us by asking dozens of questions, but we kept repeating our theory. The state cannot own a name or address as intellectual property. Finally, the judge gets it and turns to question the AG. He tries to dance his way out of answering the big question in all sorts of ways. Eventually, the judge flat out asked him if he contends the state can own someone's name or address. The AG responded by saying, "Judge, I came here to try a case, not to argue the law." The judge was not impressed and dismissed the case immediately, and wrote a letter to the Attorney General asking him to be more selective in his prosecutions. That was a fun day in court. Story 3. The opposing counsel was convinced. I'd coached my witness. He accused me of feeding him lines, basically calling the guy a liar before the poor man even finished his sentence. You could see it in the attorney's face. He thought he had me dead to rights. So, he asks the witness, "Did you talk to your lawyer before testifying?" The witness says, "Yeah, I did." And right then the attorney's eyes lit up, like he just struck gold. You could almost see the gears turning in his head. He thought he had a perjury charge gift-wrapped and ready to go. Then he follows up, all smug. "And what did your lawyer tell you? What instructions did he give?" Without missing a beat, my witness locks eyes with him and says, crystal clear, "First thing he told me was to tell the truth, no matter what. He said the lawyer's never the one who goes to jail. I am. He told me straight up that if I lie, I'm on my own." Boom. That sound you heard was the wind getting knocked right out of the opposing counsel. His whole posture changed. Shoulders slumped, confidence vanished. You could almost feel the temperature drop in the room. At that moment, every single person in the courtroom turned and looked at me. The judge, the jury, even the court reporter paused for a second. And there I was, sitting calm as ever. It was the only time I ever let myself smirk in court. I didn't say a word, but I wanted so badly to lean back, put my feet up on the table like Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." Story 4. I represented a company that got sued by a former independent contractor for breach of contract. The guy claimed that my client wasn't paying him properly under the terms of their agreement, said he was owed a significant chunk of money. On paper, it might have looked like a decent claim at first glance, but it didn't take long for the wheels to come off. During his deposition, it became clear this guy had done zero homework. I asked him whether he'd reviewed any payment records or documentation to verify his claims. He hadn't. I asked whether he'd even read through the complaint before it was filed, to make sure the allegations in it were true. Nope, he straight up admitted that he had no idea whether my client had actually failed to pay him under the terms of the contract. At that point, I'm thinking, okay, so you're suing someone based entirely on a hunch. And then it got better. When I pressed further, he basically said he just didn't like the agreement and didn't think it was fair. This, of course, was the same agreement he had willingly signed and worked under. The final cherry on top, he admitted, under oath, that he actually owed my client money, not the other way around. Fast forward to arbitration, and suddenly the guy's got a brand new story. He's testifying like none of that ever happened, acting like he's been wronged, like he's owed back pay and damages. But I came prepared. I pulled out the deposition transcript and started dismantling his testimony, one contradiction at a time. Every time he tried to backtrack or spin a new version of events, I'd show the panel what he said under oath just a few weeks earlier. By the end of it, the credibility gap was massive. You could see the arbitrator wasn't buying a word of it. It was one of those cases where you don't even need to make a dramatic closing argument. The facts did all the work for you. Needless to say, we won. Easily. Story 5. I am not a lawyer, but I was in traffic court one time and saw a lawyer straight up end a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and winds so strong that the defendant could only open his window 3 inches, and that the car had stopped on an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver's side. The cop had then testified that he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car, through a 3-inch crack in the window, on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log, to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a break and called the traffic prosecutor and the cop into his office. I'm guessing it wasn't for a nice spot of tea and some scones. Story 6. I'm relatively junior, so I'm hoping to beat this one day. I defended professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent, as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial, which was to be heard after our motion was argued. That matter was also a professional negligence matter, and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced professional negligence for many years and was well-versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Story 7. I do mostly solicitor work, so if I'm doing my job right, I don't get a whole lot of these type of moments. That being said, I had a long-time client who was being sued, and I got to shut down the guy suing him in a very satisfying way. So, my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed-upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete/confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out, or he can find himself another job. He takes the latter option, but he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice, and 5 weeks vacation pay. I got the enjoyable job of telling Kevin in front of a judge that he was not entitled to anything under the employment legislation, and the only way he could get any of that would be if he had signed the contract. The judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Story 8. It wasn't at trial, though we had one of those and I won it easily, just always stuck with me, because of how clearly the law supported my position, to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damage was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which, at that point, had been trashed. It was just some minor furniture-type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks that is notes he took during class. He is furious and sues the landlord in small claims for $5,000 state maximum because his notebooks have such huge value apparently. They hire me, and I respond, which moves the case out of small claims. It's just the way it works here. I know this is not the case for every state, but our rule is better than yours. But enough aside, this puts him at a huge disadvantage because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, no, that won't be happening, and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned, period, end of story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She did not. We proceeded to a short bench trial in the district court that we won. Story 9. I helped the prosecution rest his case. I got jammed up during spring break doing dumb spring break crap, so there I was in court to face the music misdemeanors. As I sat there waiting for my turn, I watched person after person go before the judge. The prosecutor read their charges and some information from the police report, stating what the potential max sentence was for each. All I don't remember exactly. Then the judge asked what plea they wanted to enter. Almost everyone said, not guilty, and I could see that both the judge and prosecutor were getting tired of their BS. Finally, my turn came. I was probably second to last after what seemed like hours, but may not have been. The prosecutor read off my charges and cited the police report. The judge looked at me with this, let's just get it out of the way. Tell us you're not guilty. Look, and asked how I pled. Guilty, Your Honor. The judge and the prosecutor both looked at each other, and the judge said, kid you not say again, or beg your pardon? Guilty, Your Honor. I did it. Just the way Officer so-and-so's report reads. They exchanged looks again, and the prosecutor held his papers at arm's length as if to get a better look at them and did the unthinkable. Your Honor, this all reads to me like a case of college prank gone bad. The county moves to reduce charges to XYZ. I walked in there expecting some jail time and walked out paying like $110 plus costs. I didn't really know how to feel about the scariest day of my life turning into one of the happiest ones. Story 10. I once had an appeal where the precedent, all from other circuit courts, was very bad for me. The circuit court I was arguing in front of had a decision that was very good for me, but it was unpublished, meaning that it was not precedential. My goal was to convince the court to follow its unpublished decision, not the decisions of the other circuits. During my argument, I cited the unpublished decision. One of the judges interrupts me and asks, but wasn't that decision unpublished? I answered yes, but it was well-reasoned. He replied with a self-effacing quip. I was on the panel for that decision, so it couldn't have been that well-reasoned. The audience laughed a bit. I answered quickly. In that case, Your Honor, it was at least well-written. The audience and all the judges burst into laughter. I ended up winning in a published decision, which turned the old unpublished decision into binding precedent. A bit of humor can go a long way in the courtroom, especially when you're flattering the judges. Story 11. Two high school kids spend their day pissing each other off, so they decide to drive to a fast food restaurant to fight. They park, get out, immediately approach and swing. Kid A connects the first blow squarely and solidity across Kid B and instantly drops him. The whole fight was one punch with a total elapsed time of a few seconds. The restaurant is sued for failure to protect its patrons. The case is weak. Unfortunately, Kid Bad hit the pavement hard and had severe brain damage. Attempts were made to settle, but they were after millions. We knew walking in they had two former employees testifying about large crowds building up after school. The plaintiff attorney aimed to prove the restaurant had a reasonable expectation of trouble and should have had armed guards in the parking lot. At best, their witnesses exaggerating to the point of perjury. Their credibility was shaky and being highly disgruntled for being fired. We had a list of witnesses ready to refute their claims. At trial, the plaintiff attorney presented first. He spent a long time building up the bad blood between the kids, the serious damages of Kid B, and his potential earning capacity. A lot of foundation work to build sympathy for his client. We break for lunch on day 2, after which it would be the defense presentation. As we were talking through where we were and how we should proceed, we realized the restaurant was not really mentioned at all. The plaintiff held back his star witnesses to rebut the defense presentation. The restaurant was safe, so when we reconvened, "Defense rests, Your Honor." The plaintiff attorney fell out of his chair. He begins frantically shuffling papers on his table and was stammering. The judge says, "I take it you will need a few minutes for your close." After that break, plaintiff's attorney gave one of the worst closing remarks I've ever heard. Jury, Kid B 10% at fault. Kid A 90% at fault. Story. I was a second-year associate and handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a completely BS examination of the issue, and his expert report was equally as BS. For those of you that don't know, expert testimony needs to meet a certain standard, the Dolbert standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Dolbert motion to strike his report testimony because the case was low value, under $100K, and those types of motions can be very complex, and didn't want to bill the client for it. I was so angry about this guy being deemed an expert that I came in on a weekend on my own time and drafted a 20-page motion to strike his testimony. I didn't bill the client a dime. The defendant didn't file a response to my Dolbert motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate just like me do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second expert witness, who was pretty terrible, but not quite as terrible. I also did his cross-exam. Realizing that they were in serious trouble without their primary expert, and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck, except for one very, very tiny area. So essentially, he was forced to testify with both hands tied behind his back. It was the most gratifying moment of my legal career so far. Story 13. So I called up my client's disgruntled former employee about a contract dispute that he started and that got my client into litigation. After 2 questions, it was obvious he was a lying son of a b. I didn't want to call him as a witness. He was prone to act unpredictably. I took down his story as we talked, which was easily proven false by documents, and which cast my client in a false and bad light. I did not tell him how I'd caught him in lies. Fast forward one day, I submit a list of known witnesses to opposing counsel, as required by the rules. Witness number 1 was the lying sack of crap. Fast forward to trial. My opposing counsel calls the lying sack of crap as his first witness, and the lying sack of crap acts like a lying sack of crap. He tells the same story on the witness stand that he told me on the phone. I took emails that he wrote and entered them into evidence and proved him a clear liar. My client didn't breach the contract. The party suing did. After the lying sack of crap left the witness stand, I asked the court for a brief recess. Granted, I approached the opposing counsel. My client was still willing to sign on to the walkaway settlement where no money changes hands and no fault was admitted. We offered the deal 2 months before and it was angrily rejected. Now suddenly it was accepted. Score. Story 14. I represented a man in a slip and fall case in a national chain that grills chicken. The restaurant is not supposed to clean the grills until after they close because it is a huge sloppy mess that involves using a garden hose after applying chemicals to remove all of the grease. The close down process can take up to 2 to 3 hours that involves packing up the food for the next day, scrubbing the grills, mopping, etc. Even though the corporation knew this, they refused to pay more than 1 hour worth of wages after closing time. Thus, the shift managers and cooks decided that they would start the closing process 2 hours before closing while there were still customers in the restaurant. This is really dangerous, as employees delivering food can track the greasy water into the lobby where the customers were. On one fateful day, 2 hours before closing, one of the cooks was cleaning the grills and using the hose to wash them down. This slurry is so slick that the cook has to wear a plastic smock and slip-resistant shoes for the process. While he was waiting for the chemicals to remove the grease, which takes about 15 minutes, the cook goes into the lobby tracking this stuff into a hallway to wipe down some tables. My client walks out of the restroom and slips in the greasy water. He hits his head so hard that it causes a subdural hematoma which requires surgery to relieve the swelling and blood from the brain. Go figure, the video system wasn't working that day. In any case, right after that the cook was fired, and the corporation claimed that they could not locate him during litigation. I did some research and found a relative of the cook, which eventually led to me finding him. He admitted that he was cleaning the grill, but denied that he was the one that tracked the greasy water into the lobby, as did all of the other employees. The corporation during the entire 3-week trial testified that cleaning before closing was against their policy, and it never happens. Thus, it had to be anything else that caused my client to fall. I was talking to the cook before trial because we were going to call him as a witness. He was pissed that they fired him. I asked, "Do you think they are still cleaning before closing because they are denying that they do?" He told me, "Absolutely." On the first day of trial, I sent my investigator to the restaurant at the time my client was injured, which was 2 hours before closing, to record video on his cell phone. Whether they were cleaning or not, guess what? They had the hose out and everything. I couldn't believe that they would continue to do this at the restaurant at issue in the case. I told my investigator to go back up there when there is a different shift manager and cook to see if they are doing the same thing. They were. At the end of the trial, the defense put on their general manager for the region. He swore up and down that this never happens. He was their last witness. We get up and say, "Judge, we need a sidebar." In the judge's chambers, we revealed the videos to the other side. The attorney for the corporation was freaking out. The judge let it in for rebuttal. The last thing the jury saw before going into deliberations was 5 minutes of video with audio of the hose as they were cleaning the grills 2 hours before closing. We completely wiped out their entire defense in a 3-week trial with that video. Needless to say, we prevailed. I should add, using sub rosa video against a defendant like this is very rare. They usually stop doing what they are not supposed to be doing during the trial. I guess the restaurant didn't get the memo. Story 15. Several years ago, there was a big drug bust in my town where the cops arrested about a dozen people in this garage and charged them with manufacture/delivery/possession with intent to deliver a controlled substance drug dealing, conspiracy, and criminal organization known as RICO in other places. I was appointed to represent one of the people found in the building when the drug task force raided the place. The police filed an 8-page affidavit of probable cause. Most are 1 to 2 pages for most other cases, detailing their surveillance of this criminal enterprise and the comings and goings of various participants and their roles in the enterprise. I read all 8 pages and realized that the only place my client's name appeared was on page 7, where it said the following individuals were present at the garage when the warrant was executed: Person 1, Person 2, Person 3. So he was there the day the drug task force raided the place, but there was no mention of his involvement in the criminal enterprise. His bail was set at $250,000, which is ridiculously high, and the district attorney refused to agree to a lower amount at his preliminary hearing. I filed a motion for bail reduction and showed up at the hearing loaded for bear. The DA calls the case. I approach the front, and the judge jumps right in before I could even open my mouth. Usually counsel makes their arguments first. The judge asks any questions of us he has, then he makes his decision. The judge looks directly at me and says he's read the affidavit of probable cause. He says what is alleged in there is pretty serious and a big deal in our small town. He noted how the task force had the place under surveillance for weeks to build their case, which ultimately resulted in their raid. And if the allegations can be proven, the defendants are facing some serious consequences. But he says, now turning to face the DA, he saw that my client's name appeared only once in the entire affidavit, and it makes no mention of his involvement in the drug enterprise. The judge asks the DA, why shouldn't I grant defense's motion for bail reduction? The DA stammers, we have evidence that this defendant was involved with picking up the material from Philadelphia and transporting it here. The judge looks at her again and says, did I miss that in the affidavit? She replies, no, they just recently found that out. The judge turns to me and asks me if I have anything to add. There I was, fully prepared to make this passionate argument for why my client's bail should be reduced. The deficiencies in the affidavit, my client's advanced age, his lack of a criminal record in the past 20 years, etc. I stood there trying my best not to smirk and said, I have nothing to add, Your Honor. Motion granted, bail reduced. Story 16. I'm not a lawyer, but a friend's sister went to court over a moving violation. She's an engine tuner and had built herself a beautiful first-gen Mitsubishi Eclipse with 700 horsepower at the wheels. This car inevitably attracted the attention of the local law enforcement, who pulled her over with no fewer than 8 cruisers after some slightly aggressive acceleration around a left turn. During the cross-examination, she asked the officer who'd made the call why exactly she had been pulled over. I heard the engine revving, and I saw you spinning the tires and sliding around the corner. To be clear, officer, which tires were spinning? The rear tires. So I was spinning the rear tires, and it was the back end that swung out? Yes, ma'am. That's correct. And you're sure that's what you saw? Clear as day, ma'am. The light turned green, you stepped on the gas, and the rear tires broke loose under power. The rear tires broke loose under power. There's no doubt in your mind that's exactly what happened. None at all. Your Honor, this officer is either lying or hallucinating. My car is front-wheel drive. Story 17. This is one of my dad's favorite stories. So he is out of state on business, driving through some no-name town when he goes through an intersection. Suddenly, a cop pulls him over, stating that he ran a stop sign and ticketed him. My dad insisted there was not any stop sign, but the cop did not listen. Pissed, he went back to the intersection and saw that there was a stop sign hidden behind a tree and twisted in the wrong direction. Even more pissed, he went to a convenience store that was in sight of the intersection and bought a disposable camera while the clerk laughed because he saw what happened and knew what's up. Luckily, my dad had to be back there in a few weeks for work. The cop assumed that someone with out-of-state plates would just pay the ticket, and they were shocked when my dad turned up in court, calmly presented his evidence to the judge, and strolled out in 5 minutes scot-free. Story 18. Kind of applies, I'd suppose. I practice mostly criminal defense. I fairly recently had a client who, after pleading guilty to a theft charge, contested the amount of restitution owed. Essentially, the client said, I stole some stuff, but I didn't steal all of that stuff. The victim had to come to court to prove the value of the things he alleged were stolen. Some of those things that my client denied having touched, much less stolen, were rare and valuable coins. To support his claim, he brought a statement purporting to be from a local coin dealer with the type of coin listed and its value. I knew nothing about coins, but I knew the judge knew a lot about coins, having collected them for years. The DA asks his questions. I muddle through my questions. Then the judge said he had some questions and verbally ripped this guy's list to shreds. Stuff like, you expect me to believe that blah 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 coin and blah blah condition is worth $250 when I can go online right now and find the same coin for $36. I just sat back like Vincent LaGuardia Gambini while Mona Lisa Vito was being voir-dired. It was wonderful to watch. Story 19. I have 2. One my own and one someone else's. In mine, my client was accused of not leaving this woman alone when she wanted no contact with him. He swore that they were dating and she'd call the police when she got mad. She swore she wanted nothing to do with him. She had a photo on her phone of him sitting on her porch to prove that he'd come around without her consent. I asked permission from the judge to look at the photos before and after to get context. Lo and behold, she had hundreds of photos of him, eating dinner with her, sitting on her couch, wearing her undergarments. It was glorious. In the other, a colleague was questioning a police officer about a consensual encounter with a defendant. The officer claimed that he in no way intimidated the client and that the client was free to walk away at any point. My colleague said, "Officer, you think based on what you said and how you acted that any person in this room under those circumstances would feel like they could walk away?" The officer said yes, and the full courtroom audience started laughing. Story 20. I'm not a lawyer, but this happened to my wife in small claims court. Background. We lived in a small coastal town in the mid-1990s. She was attending the local community college, which was located on a steep hill. The main road ascending the hill had most of the side streets barricaded for some reason. One day, as she was driving up the hill to classes, she happened to be behind an older man in a small truck. The man attempted to turn onto a side street, but found it barricaded, so he put the truck in reverse and backed into my wife. My wife said the man was apologetic as they exchanged information and gave her his phone number so they could work out how he would pay for the damage. When we called the number he gave, his wife answered and began to berate my wife, telling her that it was her fault and that we were going to have to pay. No way, small claims court is the answer. Our day in court arrived, and things looked pretty bad for us since it was our word against his and rear end. Accidents are usually considered to be the trailing driver's fault. Before making his ruling, however, the judge decided to skim the paperwork one last time. A slight chuckle emitted from the judge, and he asked the man if he remembered filling out the accident report. "Yes, Your Honor." "Then you probably remember stating on the accident form that you put your truck into reverse, backing into the car behind you. You've incriminated yourself and lied to the court. I'm awarding the full amount. Case closed. Consider yourself lucky I'm not charging you with contempt." The wife and I high-fived in the hall outside the courtroom. Story 21. I was helping a client gain custody of his infant daughter. He insisted that baby mama was on drugs, and his first attorney tried in vain to get him to understand just how favorable our state is to 50/50th time, unless he can prove by a pretty high standard that she was on drugs. The problem is that he kicked her out because he had suspicions. But then one day found needles and a substance in the other baby daddy's bedroom. This was all wrapped up in an old dish towel with a band, the type you put around your arm for shooting up, name, and a spoon. She tells him every frigging lie, "Don't know, not mine, only tried once," etc. But he refuses to believe her and kicks her to the curb. So he fires first attorney and hires me, and I go straight into client control mode, heavily managing expectations while doing everything I can to put requirements in place to catch this drug use, and we're getting nowhere. The trial problem we have is it's a one-time thing. She's a good liar even by legal standards, and we have nothing current to show a pattern. But he insists, so I file to restrict her time, and we go to court. She's such a good witness, and the judge buys every bit of it. On cross, she testifies that she only ever shot up the one time ever, and that's the only time she ever used anything illegal, and she just knew how to shoot up because she didn't know. I thought I had a pretty good cross. It took some time, but I felt like we got what we needed. But we lost, and the judge gave her essentially 50/50th time, ordered us to mediation, and set up some regular drug screens. We go to mediation and put in place a parenting plan that sets up a little more detailed 50/50th custody schedule, but also requires regular urine drug screens and some more detail about those screens so we can be sure she isn't constantly trying to beat the tests. Best I can do with the facts. I caution him that all we can do is pay attention to the screens, stay on top of it, and take her into court under an emergency motion at the first slip-up. But she is so good, she's supposed to take the screens within 24 hours of a request, but always has an excuse and is just a couple days or so late. Also, somehow almost all of her screens are on Wednesdays. Later find out a friend works those days. Also, mysteriously, she refuses to give me direct access to the screens, but provides them to her lawyer who faxes them to me. I immediately start sending faxes. He was old school, no emails and an a-hole, so no phone calls, and telling him I consider this contempt and he better cure it or I will file. My client is furious at each contempt, but the standard for this is so high, and we've already been in court once and didn't do well, so I really needed to build a case. So finally, we get quite a few weeks of ridiculous behavior, and my more than reasonable attempts to address it with her attorney. I filed for civil and criminal contempt, and we go to court. An important detail is that she has another baby daddy who was fighting custody at the same time for the same reasons and has required drug screens. I'd been in contact with his attorney, and we were sharing information. I found out that the night before our hearing she had completed a urine drug screen and passed it. So when we get there, I caution my client about getting his hopes up, remind him this is a long game. She's late, and the judge starts without her. No flying faffs given. Her attorney surprisingly withdraws. He says it's because of a lack of communication. She finally shows up as I'm giving the rundown of my motions. I run through the timeline of missed screens, delayed screens, a screen that failed because her sample was too diluted, etc. And the judge looks at her, and she gives all the excuses in her very sweet and innocent way. The judge listens, then asks how she would test that day. She says she will be clean, so they screen her. And she fails for exactly what we expected. The judge asks why, and she tries what are clearly excuses this time, changes her story to fit the facts, and he cuts her off and tells her he doesn't believe her. He orders her to 4 hours a week with supervised visitation, and she has to pay dad support until she completes an intensive outpatient drug treatment program, at which time she can regain some of her custody. That little girl just turned 5, and mom has never visited, and to my knowledge has never completed any treatment. She also hasn't paid a dime, which my client doesn't care about and doesn't care to pursue. It's a small town. He said he saw her in a restaurant once, and she walked right by her daughter and didn't acknowledge her. I've seen her out once with friends, partying without a care in the world, it seemed. Story 22. I've had a couple such enjoyable moments, though they have all been no further questions moments. As I rest, my case is not something I get to say in family court. I apologize in advance for what is likely to be a pretty lengthy post. In the first ever domestic violence restraining order DVRO case I had as a new attorney, I represented a woman who has broken up with her ex-boyfriend after he hit her. She filed for a DVRO when he continued to harass her and show up uninvited to her place. The process for getting a DVRO, at least in my state, is the victim files documents describing the alleged abuse, and a judge decides to grant a temporary restraining order with a hearing scheduled within a couple weeks where each side can present their case. Even after my client got the temporary restraining order, her ex continued to try to contact her, including randomly showing up where always she took her dog for a walk at 5 a.m. the morning of the hearing, even though this was 25 miles away from where he lived. At the hearing, even before either party got to testify, the judge reiterated that any violation of the temporary restraining order, including attempted contact with the victim, was grounds for a permanent DVRO being issued. The judge ended up ordering a brief recess before we were to introduce evidence testimony. During the recess, my client went to the bathroom, and the ex decided it would be a good idea to follow her into the bathroom to talk her out of pursuing the DVRO. He had not noticed that the bailiff was also using said bathroom, and the bailiff immediately ordered him out of the women's bathroom and threatened to arrest him. When we got back into the courtroom, X took the witness stand to testify. I asked him if he had just attempted to enter the women's restroom to make contact with my client. When he answered affirmatively, I smugly stated that I had no further questions. The judge tore him a new one, and the DVRO was immediately ordered. On one other DVRO case I handled, I was defending a husband who was accused of completely unsubstantiated and clearly fabricated abuse by his train wreck of a wife. My first question for the wife when she took the witness stand was, "Isn't it true you made these allegations and are requesting this DVRO solely for purposes of gaining an advantage in custody and support proceeding?" I obviously assumed she was going to deny it, and was really just planning to try to get her angry on the stand so she'd slip up and give inconsistent or conflicting testimony. When she answered yes, the judge looked as surprised as I was. I immediately stated that I had no further questions, despite the fact that I had prepared at least 40 to 50 questions for her, and sat down. The judge tossed the case moments later. Story 23. Not a lawyer, but my wife is, also not even in court, but let me tell you how I won my case last night. I am about to go to bed, and I remembered putting my charger on my wife's desk. Of course, I go over to grab it as I need it for my phone, but lo and behold, it's plugged into the wall without a phone on it. So I take it and proceed to leave the room, only to have my wife announce that that is hers. Now I try to avoid little tussles, but something seemed wrong. I told her I placed it on her desk, and so that it must have been mine as I did not see her go anywhere else. She responds with, "I just pulled it from my purse," to which I reply with, "Did you?" Now my wife as a lawyer loves proving me wrong, so she proceeds to go off to her purse to prove it to me. But wait, she pulls her charger from the purse. She just hands me mine and I laughed and walk off as she laughs and says, "Shut the foffs up," in a giggly tone. And that, folks, is how I beat a lawyer. Story 24. This was really an aha moment about stereotypes. Our client was a Spanish-speaking young man from Ecuador who had come to the U.S. on a visa for a job at an orchard in Florida. He also ended up working weekends in construction where his hand was cut off in an accident. We sued the manufacturer of the equipment. At trial, defendant's lawyer sneered at our client about his estimated damages and asked about his education and work history. The client testified that he took college courses in Ecuador before coming to work in the orchard and that his goal was to be a full-time computer analyst. Defendant's lawyer said, "You may have been working in Ecuador toward becoming a computer analyst, but the fact is that up to the date of your accident, you only held minimum wage jobs picking fruit and doing construction work in the United States. Isn't that right?" The client, "No, sir, I was in charge of the computer system at the orchard. I never picked fruit." There was silence in the courtroom for a moment. We couldn't rest our case, but it sure was a wake-up call for defendants who had never considered this possibility. We won. The jury awarded $2.5 million in damages. And just to clarify for those who don't already know, damages are often calculated based upon a plaintiff's potential lifetime earnings, which is why it matters whether an accident prevents you from earning minimum wage or whether it keeps you from a job with the potential for much higher earnings. Thank you for watching. If you enjoyed this video, be sure to give it a thumbs up, subscribe, and hit the bell icon so you never miss an update.